Now, certain provisions of the Refugees Act have been declared unconstitutional and invalid by the Western Cape High Court earlier today. The judgment gives to some asylum seekers against Home Affairs in terms of deportation. Immigration expert Ashraf Essop joins us for more. Mr. Essop, thank you so much for your time and for joining us this evening. So maybe let's just perhaps start with you explaining what were the legal and the main grounds or constitutional principles underlying the court's decision.
Good evening and thank you for the opportunity. So when approaching the constitutional imperatives in this case, we have to have some background to what exactly had happened. In 2000, the Refugees Act, 2020, the Refugees Act was amended. And there were certain provisions that brought in new, let's say, operational requirements as to how a person can approach the refugee reception officer and under what circumstances he may or may not be granted refugee status. So at the heart of this matter was really the applicant saying that the amendments, the effect was to disbar asylum seekers from doing so if they had two events. If they had no immigration status, solely due to their non-compliance with procedural requirements, which they said was now an unjustifiable violation of the Constitution, as well as the right of non-return, which is known as non-refoulement, enshrined in both international customary law, as well as in terms of Section 2 of the Refugees Act. So the judgment goes into various parts, but I think the one that we really need to focus on is the impunged provisions and not the amicus curiae, the rights of the child, etc., that was also covered in the judgment. So what exactly meant, by who was excluded from being granted refugee status?
Right.
Section 4, the one that we're now dealing with, 4.1, said that if a person comes to a refugee status determination officer, also known as RSDO, these are officers attached to what they call refugee reception officers. For example, the Desmond Tutu Refugee Reception Office based in Maravastad in Pretoria is one such office. And there's an RSDO, there's many RSDOs there. But if that RSDO believes that someone has committed an offense in relation to the fraudulent possession or acquisition of a South African identity card, passport, travel document, temporary residence, or permanent residence. That's the first one, right?
Right.
The second one is if the RSDO believes that the applicant or the asylum seeker entered the Republic other than a port of entry, which meant he jumped the border, right? And he fails to satisfy the RSDO that there were compelling reasons for him to have jumped the border, or he failed to report to the RSDO or the Refugee Reception Office, also known as RRO, within 5 days of a asylum seeker's transit visa, and unless he had compelling reasons. Now, it's very interesting, these compelling reasons they put in the Act is such as hospitalization, institutionalization, or any other compelling reasons. And provided that it won't apply to a person who's already in the Republic on a asylum transit visa. That is clear, right? So he failed to report within 5 days. And then there's Section 21, capital 1, capital B, which says that if an applicant in terms of Section 23, if he's not in possession of that asylum transit visa, he must be interviewed, but not by the RSDO. He must be interviewed by an immigration officer to ascertain whether there was a valid reason as to why he was not in possession of such a visa. So you can see that the act was brought in with the purposes of trying to find ways of streamlining how asylum seekers enter and remain in the Republic. There are certain regulations attached to that, and those were also under challenged. Now, for example, if a person was given an asylum transit visa, and he must be able to provide proof of the change of any circumstances between the date of the issue and the date of the application for asylum. Now, we all know that if you march off within 5 days to any refugee reception office, you're unlikely to get immediate help. So that was one of the challenges beyond the asylum seeker's help, or beyond his own means of helping himself. So what did this all mean? Since the date that they were published and took effect on 1st January 2020, so the stated preamble to the changes was to include further provisions relating to disqualification from refugee status. We've already covered some of those, right?
Right.
So we can understand where the act was heading. Now, one of the problems that the judges had was that the RSDO, he had the sole discretion. This was in his total control. If he had reason to believe that the foreigner had committed any offense pertaining to unlawful documentation, or what was compelling reasons, he was now in charge of this entire process. And the only guidance that the court found that the refugee status determining officer had to guide his discretion was those compelling reasons that I spoke about earlier on, which referred to hospitalization, institutionalization, and other compelling reasons. Now, Section 21B doesn't confer a power on the refugee status determining officer,
Right.
but now on an immigration officer to ascertain whether there were valid reasons. So you see, the court was not happy with all of these, let's say, challenges put up against granting refugee status. And the court went in great detail into some of the very important judgments already handed down by the Constitutional Court in cases such as Ruta and Abore and Ashebo. So it was very important
Right.
that the court then said, look, we have a very important provision of non-refoulement, and it's already contained in Section 2. Section 2 was not amended by the 2020 amendments. Basically,
Ashraf,
it said that, yeah.
I'm sorry to come in there. We have run out of time, but I just want us to wrap this up in terms of just what are the changes that you believe could lead to the way in which refugee cases are then processed in South Africa, just in 30 seconds, because of now how this decision has been taken.
There must be due process. Applicants should not be frustrated by administrative bunglings. There should be more resources available for them. You have to go in person, but you can use other means such as Zoom. You can present documentations online. It doesn't have to be a one-on-one physical as a first step, because remember, you got to get yourself to a refugee reception office within that period. What it says is, if you fail to do so within that 5 days, it's not the end of your matter.
Right.
In certain instances, if you were a holder of it and you couldn't get it extended, then the law was protected you in Scalabrini, and you had an automatic extension.
All right, Mr. Ashraf Essop, thank you so much for your time and just unpacking that decision for us from the Western Cape High Court. That's migration expert Ashraf Essop speaking to us there about that decision taken by the Western Cape High Court, declaring some of those sections within the Refugees Act as invalid and unconstitutional.